Let me welcome you to this marvelous event. Thank you for coming out in the snow. For those of you who came all the way from New York, thank you for the long ride up. This lecture is made possible by Stephen Yee of Brown class. Can I say, Steve? The Brown class of 1981, and Eric Theophile. And then, wait, I'm not done. I'm going to say a few more words. They've created a family lecture fund. They came to us to suggest a lecture series on the family in honor of their first wedding anniversary. And the dream first lecture was the lecture we're going to hear tonight. David Boies and Ted Olson. The very first conversation we had, we said, wouldn't it be great? And here it is. That idea of their first anniversary stands, as we'll talk about tonight, for a revolutionary change. And I want to just say a word about how meaningful it is. It's easy to be cynical if you study public policy. Why, just yesterday, King versus Burrell at the Supreme Court, Justice Scalia, I'll just read a little bit of the transcript. Congress enacts a statute that takes care of the problem. They do it all the time. Solicitor General Donald Verrilli, this Congress, Your Honor? Laughter. Not this Congress. This lecture is an antidote. It's an antidote for a number of reasons. One, great change is possible. We're seeing enormous revolution, really, in our lifetime. So when you start feeling cynical and nothing ever changes, this today tells you that's not true. Second, individuals can make a difference. And we're going to hear from two individuals who made a huge difference. Lots of individuals involved. Individuals can matter. For the students in the room, your generation makes all the difference. People began to notice, wow, look, public opinion is changing on same-sex marriage. Yeah, it's changing because first the millennial, and then what do we call you, the post-millennial? Because you guys came online on public opinion polls, and you don't even want to talk about people taking away people's rights. And so when it's 80 to 20 in one generation, it changes everything. No one really quite parsed that out. They thought the 65-year-olds had changed their minds. Not so much. It's your generation coming online. And then finally, I love the idea that this conversation is taking place as an anniversary celebration of Steve and Eric's first wedding anniversary, because it reminds all of us who study and think and talk about policy that we don't check our hearts, we don't check our emotions, we don't check our love at the door when we begin to do our studies. It's about our emotions as well as our heads, or as David and Ted put it in the last chapter of their book, Love Wins. So, thank you, Steve and Eric. Now, and now the pleasure of introducing our speakers. This is a very rare combination in our two speakers. They're brilliant, they're successful, they're passionate for justice, and those of you who've already met them know they're really nice. Start with Ted Olson, Theodore Olson. If you walk into his office, there you'll see him with presidents and so forth. There's Ronald Reagan shaking his hand, etc. But he says people don't pay attention to that. What they pay attention to is this display of quills. You see, if you argue a case before the Supreme Court, they give you a quill. And he's got a display of then 31 quills, now up to 61 cases before the Supreme Court. His bachelor's degree is from the University of the Pacific, his law degree from California, UC California at Berkeley. In 1981 to 1984, he was the Assistant Attorney General in charge of the Office of Legal Counsel. Under the Ronald Reagan administration, he was Ronald Reagan's lawyer through Iran-Contra. In 2000, he represented the Bush campaign in the famous case, Bush versus Gore, that decided who had won the 2000 election. From 2001 to 2004, he was Solicitor General of the United States, now a partner at Gibson, Dunn, and Crutcher. His vita lists honor after honor after honor. I'll just mention a couple. He's on the board of directors of the Ronald Reagan Presidential Foundation. He's on the board of directors of the National Center for State Courts. I'm going to stop there, ... and just give you my favorite honor that he mentions. Time magazine named Theodore Olson one of the 100 most influential people in the world. I like that one in particular, and that probably sums it up. Ted, welcome. I'm going to introduce them both at the same time. Ted Boies. David Boies, Ted Olson, get it right. David got his Bachelor of Science from Northwestern University, where he was Phi Beta Kappa. His law degree is from Yale University and an LLM from NYU. He was chief counsel and staff director for the United States Senate Judiciary Committee in 1979, was special counsel who essentially ran the antitrust case, the U.S. Department of Justice antitrust suit against Microsoft. And in 2000, after the Florida jump ball in the 2000 election, the people in the Gore campaign did two things. First, secure all the ballot boxes in the state of Florida, and second, call David Boies. He's got a long list of honorary degrees, NYU, UNH, the Chicago Theological Seminary, interestingly enough. He has been named National Global Litigator of the Year 7 times. Again, honor after honor after honor, but I'll just give you my favorite one. Time magazine. You're way ahead of me. Named him one of the 100 most influential men in the world. David, welcome to Brown. We're going to have Ted and David each say a few words, 5 or 10 minutes, 10 minutes. We'll then have a conversation up here. We'll then throw it open to the floor. I will be Justice Scalia and keep your questions very short, but there are the microphones. Ted.
Thank you. And thank you for being here tonight. It's a great privilege for David and I to be here at Brown to talk to you about this issue that is so very, very important. I will say one thing about that Time 100 thing, that with the letter came from Time magazine right around the beginning of April, and my secretary who opened up the mail came in and said, "This is one of the best April Fool's things that she had ever seen." And I looked at it and I said, "It really is. This is really amazing." So we don't take that too seriously. David and I have been good friends for a long time. We are pretty close to the same age. We're exactly 6 months to the day apart. I'm the older one of the two. But Dave, we both were born in Illinois. We both grew up in California, attended public schools in California. We both went to law school just about the same time. David took his summer internship at a law firm called Gibson, Dunn & Crutcher in Los Angeles. And I took my summer internship, this is between your second and third year of law school, at a place called Cravath, Swaine & Moore in New York City. And then after we graduated from law school, he went to Cravath and I went to Gibson Dunn. We knew about one another. I had read about David's famous cases many times over, including many of his famous cross-examinations. David is maybe, there isn't any question, the greatest cross-examiner of any lawyer in the country, and a book should be written about the art of cross-examination and how that can work out and change the complexion of an entire case. So we knew a little bit about one another, but we were on opposite sides of the Bush versus Gore case, and our families came together after that, and we spent time together. We did some biking in Europe, and we enjoyed dinner and wine, good wine together. Our wives have been very good friends. Both of them are very accomplished lawyers. And we kept talking from time to time about, well, maybe there's something that we could do together. We could work together. And then in the latter part of 2008, after California, the citizens of California enacted something called Proposition 8, which overturned a California Supreme Court decision which had granted citizens of California the right to marry the person that they loved who happened to be of the same sex. That was a decision in May of 2008 by the California Supreme Court, recognizing under the California Constitution a right to equal protection under the law and the due process of the law, the right to get married like other citizens have in California. A campaign was organized to put on the ballot to change the Constitution of California, to make marriage recognized or valid only between a man and a woman. In November of 2008, that passed. There was $40 million spent on each side of that ballot proposition, and the citizens of California enacted that restriction on the right of their citizens to get married. That was the same election that President Obama was elected to be President of the United States. So it seemed anomalous to many of us that the state of California, a place which respected pioneers, innovation, respected differences between people, would take that step of taking out of the Constitution the right of people who love one another to get married in California. And David and I, we talked about this later, were both stunned, since we had grown up in California, that this could really be happening in California. I was contacted not long after that by some people in California who wanted to mount. They had lost the election. Some people thought that, will we do put it on the ballot again? Maybe we'll win next time. But the people that contacted me thought, we spent $40 million to try to defeat Proposition 8 and we lost. How are we going to raise that money? How do we think that it's going to be different the next time around? We need to go to court. It's the constitutional right under the federal Constitution for individuals to marry the person they love, to be treated equally with other citizens. When I was contacted about this, and I was in part contacted because I'd had experience in the Supreme Court on various different types of cases. And while some of the people didn't think that I'd be interested in taking on this kind of a case, several people there said, well, give it a try. Maybe he would be interested. And I was. I felt it was wrong to treat our fellow citizens in California in a way that discriminated against them and put a legend in the state constitution that these people are different. They're not entitled to the same rights as the rest of us. It's okay to discriminate against them. They are not okay. That was basically the message that was on the ballot, and I felt that that was wrong. When we started to assemble a legal team to challenge this in federal court, we felt that because my background had been involved in Republican politics, and I had been known as a conservative, that it would be wonderful if we could assemble a legal team of someone on the opposite side of the political spectrum, so that we could present the message to the courts that this was not a Republican or Democratic issue, or a liberal or conservative issue. This was an issue about human rights and human decency that spawned the entire political spectrum. And David is the head of his own great law firm. I am a part of a great law firm. We thought we could put the two law firms together. We could present this unified picture. We could, because of the novelty of the fact that we have been opposed to one another in Bush versus Gore, we thought that they would give us immediate access at a high level to exposure on television, radio, the print media, and so forth, because we felt that it was exceedingly important as a part of our legal campaign to try to change or try to have an effect on public opinion. Because we felt that we could take this to the Supreme Court. We felt that if we could get it to the Supreme Court, we felt that we could win, and then the rights of our clients would be recognized as equal under the Constitution, but it wouldn't be a complete victory if the American people rejected that decision, as the American people have done from time to time with court decisions. We thought it was very important, therefore, to win in the court of public opinion, to affect in whatever way we could. We didn't imagine that we could do everything, but we thought we could do something about it, because people were going to watch us. People were going to ask us questions about what we were doing together in this case? Why did we feel that we were right? Why did we feel that our people that we were represented deserved to be treated equally? Why did marriage make a difference? What about civil unions? We wanted to be able to explain those things, and we thought we could do it because people started calling us the odd couple. And our wives are upset about the fact that they started saying strange bedfellows. But the novelty of it allowed us to go out there and speak. David wrote a piece in the Wall Street Journal. I wrote a piece in Newsweek that was on the cover of Newsweek about the conservative case for gay marriage. We were on this television show, that television show, and every time there was a court appearance, we would have a press conference and we'd talk about our clients' rights. And we would answer questions. We'd answer as many questions as anybody would ask because we felt that if we could talk to people, we could change, we could have an effect on public opinion. And so we did this right from the beginning. We also invited 2 documentary filmmakers to start to film the process right from the beginning all the way to the end. It turned out at the end that they did 700 hours of film in meetings, are preparing our witnesses, hearings on the courthouse steps. There was the Ninth Circuit Court of Appeals allowed cameras in there, and they had that. They put it together in a documentary that HBO bought and put together called The Case Against 8, which was a beautiful movie about showing the whole projection of this case, which is another way to communicate with the American people. And then at the conclusion, David and I wrote a book, which we called Redeeming the Dream. We take that, of course, from Martin Luther King, about the dream of all Americans to be treated equally and to have respect from the Constitution and their fellow citizens. And we thought this was about redeeming the dream of gay and lesbian citizens to be treated with that same level of fairness and equality and decency and respect. And so we have that book as well. So we'll talk some more, and I don't want to take up more time than I was allocated. And I know you want to hear from David, so that's just sort of a little bit of a picture of the panorama from start to where we are today. And I'll turn it over to my colleague, David.
When Ted called me and asked whether I'd be interested in joining him in a lawsuit to try to overturn Proposition 8, I immediately said yes. That decision was not so clear in 2008. And indeed, one of the things that we found was that a majority of the people, including a majority of the people who had fought for a very long time to advance the equal rights of all citizens, regardless of sexual orientation, opposed that lawsuit because they thought it was too early. They thought that it was too dangerous. They thought that the Supreme Court would be hostile and that we would set back, not advance the movement. But I believed at the time that it was the right thing to do for several reasons. First, this is the defining civil rights issue of this century. If you look at this country and our society, we have enormous areas of discrimination that remain based on race, gender, ethnicity, religion, economics. But there is only one major area in which our government continues to discriminate against its own citizens, and that is based on sexual orientation, with very few examples, mostly in the gender area. Government discrimination against its citizens based on these factors has been eliminated, but not in the area of sexual orientation. In the area of sexual orientation, people were still told that simply because of your sexual orientation, you cannot marry the person you can love. In many places, you can't work at the job that you want to work at. You don't have any of the protections that ordinarily governments are giving its citizens, and indeed, you have the government taking those protections away. That was probably the most important reason that I thought that this case had to be brought, because there are only 3 states that we'd succeeded at getting marriage equality without a federal court challenge. No court had ever held that marriage equality was a constitutional right under the federal Constitution. It had been tried once decades earlier, and that argument had lost. Nobody had tried it again. But this was a way of establishing marriage equality, not in a single state or community, but throughout the United States. It was a way of establishing that basic human right to marry the person that you love for everybody, regardless of where they lived. And it gave us an opportunity to begin something that we thought we could win. Looking at the cases, we believed that we could win this case. We believed that there were at least 5 votes on the United States Supreme Court to establish a federal constitutional right for marriage equality. But even if we didn't, we were convinced that bringing this issue to the American people, making the American people listen and think about this issue, was something that was going to change hearts and minds. It is true that the primary thing that has turned this country around have been people of your generation and a little bit earlier, a little bit older, and a little bit younger. 75 to 80% of everybody 30 and under favors marriage equality. We have changed a lot of people, a lot of 65-year-olds, but we haven't changed enough to have made the change that you've seen in this country. That's because people have been able to be affected by, it's not only that the young people now vote and answer polls, it is because the young people are making their parents and their grandparents change. It is young people who are confronting their parents and grandparents with these prejudices, just as happened 50 years ago in terms of the movement for racial equality. And those two things in combination provided a powerful motivating force here and gave us confidence that this was a case that we could win. It was also, from a personal standpoint, it was an opportunity to work with Ted, for whom I can tell you, having been against him in Bush v. Gore and with him in marriage equality, it's a lot more fun to be with him than against him in the Supreme Court. But he's a good friend, and it has been really one of the great personal and professional experiences that I've had to work with him on a case not only of importance, but one that we could work together on. Most lawyers are never happy when somebody else is doing something in their case. No matter how much you like the person, there comes a time when you say, gee, I wish I were up there. I wish I was saying that. I wish I were doing that. The great thing about listening to Ted is I've never had that sense. Just a small diversion. You go through a trial, at the end of the trial, there's a closing argument. When you're the plaintiff, you go first and last. You go, the defendant goes, and then the plaintiff gets to go again. The hardest argument that you make in court is the plaintiff's rebuttal argument. It's that third argument, because you can't prepare for it. You've got to be responding to everything that the other side has said, and yet you have to do it in a way that brings the whole case together for the judge, so the judge now really understands the issues, understands why you're right. It is, I think, it is certainly one of the most important, if not the most important, parts of a trial, and it is the most difficult. Ted did the closing argument at the trial, and it was the best 30 minutes of courtroom performance that I've seen in 50 years of practice. It was seamless, it was persuasive, and it went down every single one of their points. To do that, and it sounded like he'd rehearsed it, which he obviously wasn't able to do because he didn't know what they were going to say. But it was a great experience, and so one of the things that most comes out of this for me is the progress that we've made on a basic civil rights issue. But it's also been a great personal pleasure to have the opportunity to work with my friend on this issue. It is also, I think it's worth saying, and it's important to say, that none of this, I think, could have happened without decades of preparation, decades of getting this case ready to be brought, decades of performing the legal underpinnings that we all relied on, and most important, decades in slowly changing the mindset of this country about discrimination. We talked about how important it is that young people have a different view of this than people who grew up with me. But I think it's worth stopping a minute and understanding why that's so. Contrary to what you may believe, it is not that you are simply better people than we were. Although it may seem that way sometimes. One of the things that you had the advantage of is that growing up, you knew people of varying sexual orientations. They were your friends. They were, in some cases, your parents, your uncles, your aunts. They were people who taught you, who treated you, people who you saw in your everyday lives. And when you grow up with people, whether they are people of different genders, religions, races, sexual orientations, and you know that everybody shares the same basic values, everybody has the same basic humanity, it becomes impossible to tolerate the stereotypes and the discrimination that is inherent in people's differences and the emphasis on those differences. And just as it was always easier to discriminate on basis of race or religion against people who you didn't really know, it was only possible to discriminate based on sexual orientation when you grew up in an environment in which you did not know people of differing sexual orientation. When I grew up in a small farming community in northern Illinois in the 1940s, I didn't know anybody who I knew was gay or lesbian. There were gays and lesbians in that place, as there were gays and lesbians all over the world. But because of the brutal discrimination in that era, they had to hide, and most of them felt they had to hide that sexual orientation. Starting more than 50 years ago, some incredibly courageous people began to come out and began to express their sexual orientation. And that, excuse me, that more than anything else, slowly, gradually, decade after decade, year after year, changed the consciousness of this country, made it possible for you to grow up knowing people of differing sexual orientations in an ordinary, comfortable, normal way. And that is what I think most prepared us and most prepared this case for what we've been able to achieve. And I think it's a testament to those people. And one of the problems with pioneers is you don't get any credit when it's happening. And by the time it succeeds, you may have passed on or have gone to other things. But for those people who made those contributions, who built that foundation, those are the people that really deserve the credit. Because even all you young people, you were able to achieve the state that you have been able to because of what they did, because of the foundation they built. And you in turn have made it possible for us to help change the American consciousness. So it's been a journey. I think it's been a journey that Ted and I have both believe has been a privilege to participate in. It's been the most meaningful case I think that either of us have ever done. It is a case that will stay with us for a long period of time. It's a case that we hope the United States Supreme Court in June of this year is finally going to decide once and for all. We now have 37 states in the District of Columbia that have marriage equality, representing 70% of the American people. But that 30% we're only going to get if the United States Supreme Court decides, as almost every federal court, appellate or otherwise, has decided, with only two exceptions, which is that the federal Constitution guarantees everyone the basic human right to marry the person they love. And that's what we're looking forward to in June. And I think that there have already been a lot of celebrations around the country, but I think that is going to be the biggest celebration when it comes. Thank you.
Lovely. So we'll talk a little bit, and then I'll invite you all to come and ask questions. And let me just get this over with. Let's just get this done. The first obvious question, which is the Bush v. Gore question. David, I'll start with you. Is there anything, as you think back 15 years ago, is there anything you could have done differently? And David and Ted, both of you, is there anything the court might have done differently? One of the justices wrote that what's really at risk here is the reputation of the court. Is there now, with 15 years of hindsight, something the court might have done differently, better, or not?
Well, differently and better, they could have decided the other way. But I don't think there was anything that we could have done. When we started off with the case, we thought we had to win the case in Florida. We had to win the issue as to how the votes would be recounted, and if they would be recounted, from the Florida Supreme Court, because that is what had always happened. It had been decided at the state level. The Supreme Court actually heard the issue twice. Not the same issue, but they heard appeals from the vote count issue in Florida twice. The first time they sent it back, 9-0. The second time we came back, when they took the case and stopped the vote counting, which was a 5-4 decision, and an unusual 5-4 decision because there was both a dissent and an opinion explaining the arguments. It was clear that this was going to be, at a minimum, an uphill battle to convince the court, the majority of the court. And I do not believe that there was anything that we could have said or done at that point that would have changed minds, and things that some of the justices have said afterwards, I think, underscores that. I think that the thing that can sometimes get lost when you're talking about a case that so divided the court and so divided lawyers and the public at the time is that there are a number of cases where the Supreme Court makes decisions that are close. And a lot of those decisions are decisions that a large number of people, maybe 49.9%, sometimes even a majority of people, think are wrong. But we have a system of resolving disputes in this country that, while not perfect, is the best that anybody's been able to devise over an awful lot of centuries, which is a rule of law administered by judges. And you may not always agree with the judges, you may not always think they've done their job right, but that's the process by which we, in applying the rule of law, govern ourselves. And so I think that while I think it's important to think about these cases after the fact, I think it's important to point out what has gone wrong, if you think that it's gone wrong, in the hope that it's not repeated. Although the court did say that this was for the purpose of this case and not for precedent generally. I think that you don't want to lose sight of the fact that you don't want to get buried in the past. Justice Scalia keeps saying, move on, get over it. And while I don't always agree with Justice Scalia, or maybe even very often, I do think he's right.
Wait till he hears that.
Yeah, right, exactly right. It will not come as any surprise. But I think he's right in this respect. I think that I think it's important that the country move on from that.
I agree with David about the fact it happened. I watched David's legal team, and there's some of the finest lawyering I'd ever seen. We each had, but this was 35 days, the most intense legal, political, media circus that's ever really happened in history. Well, no question about it, because everything was going on very, very fast. We had to handle multiple cases that were going on in courts all over the state of Florida. We had to handle the district court in Federal District Court in Florida, the 11th Circuit Court of Appeals, which is the appeals court for that part of the country. We had 2 cases in the United States Supreme Court, all in a space of 35 days. We had, David and I each had responsibility to go out and talk to the public about our position, because in a case like this, you want to be able to explain to people why it is that you're taking this position, and especially with 2 candidates running for president. I would watch David, and I guess David assigned someone to watch me. I probably didn't want to watch me, but I watched David, and I was enormously impressed with the work that he and his team had done and how carefully and thoughtfully they expressed their position in very simple, understandable, persuasive ways. I kept learning from David about how good he can be with respect to explaining. You could see it up here. The first Supreme Court case from the Florida Supreme Court took a period of 14 days from the date of that decision to the date of the Supreme Court of the United States, and there were briefs and arguments and everything that took place in that interim. The second one was 4 days, from Friday afternoon when the Florida Supreme Court rendered its decision to Friday night when we filed our petition for the Supreme Court to take the case and stop what we thought was an inappropriate recount. They did that the next day. Sunday, we filed briefs in the 50-page printed briefs in the Supreme Court. Monday, we argued the case, and Tuesday it was decided. The Supreme Court's never worked so fast in history. And the legal work was extremely well done. I'll say one thing about since David mentioned the earlier decision as 9-0, we were successful in convincing the Supreme Court that what was going on in the Florida Supreme Court needed explanation. I will put that in the most benign way that I can. So that it was a 9-0 decision to send it back. And then there was a 7-2 decision with respect to issues involving the way the votes were being counted, and a 5-4 decision that stopped the votes. So we always think of this as 16-2. But I'm just kidding about that. The experience was fast and intense, and I certainly speak for myself by saying I have enormous respect for all of the justices on the Supreme Court. They were doing the best they could. They were making a decision that you could have done either way, and people would have been upset or happy, but still, at the end of the day, respect the institution of the Supreme Court. And people in foreign countries say, isn't it remarkable? You had this 35-day debate intense debate over the future of the United States and the future of the presidency, and Al Gore gave an extraordinarily gracious speech at the end, and it was over. And people still debate it, but no one went into the streets. So it was an interesting, unforgettable experience, and it surprises people. It brought us close together as opposed to making us enemies.
I mean, one of the things that happens in a case like that is that you are so in depth into it that none of your friends want to talk to you about the case anymore. I mean, you're too far into the weeds. Your children's eyes glaze over. Even your spouses get a little tired of it. The only person that really understands it as well as you do it, is interested and obsessed with it, is the person on the other side. And particularly when the person on the other side is somebody who you have great professional respect for, but also as a person of great integrity. I could not have disagreed more with the validity of Ted's arguments. But he made them effectively, and he made them with integrity, and he made them in the highest profession, the character of our profession, which recognizes that advocates play a role in the justice system, and judges play a role in our justice system, and it's not the same role. We get kind of cross when judges begin to interfere with our trying a lawsuit, and judges get very cross when we try to interfere with their right to make the decision. So it was something that, as Ted says, it had to be decided. It got decided. I have a better chance of convincing Ted the wine I make is better than the wine he makes than I do of convincing him that it was decided wrong. But we'll probably continue to talk about it.
So let's get you both on the same side and move on to the case about Proposition 8. You have a marvelous description in the book, and at one point, Scalia asks you, Ted, he says, when did it become unconstitutional to exclude homosexual couples from marriage? When? 1791, 1868? When? I can just hear him pounding the table. And you write that was precisely the core of the case, and then you describe your answer. Would you share that exchange, why that was at the core of the case, and just tell us the story of how you answered
Well,
that?
first of all, I'll say, when we prepare for an argument in the Supreme Court, it is an intense preparation effort. We read everything, we talk about it, we make up questions, we do moot courts where we put one another through the paces, and we did several moot courts where I stood up and was interrogated by people who were asking hard, difficult questions. And so the hope is that by the time you get to the Supreme Court, you are well prepared. You may not anticipate every question, but you understand what the issues are. You understand what your position is. They've been put through a crucible of testing. And so I liken it a little bit to a cornerback or safety on a professional football team. When the other player that's gone out for a pass makes a move, that defensive player has got to anticipate or react in a way with he's turned left, now I must turn left. So you have to sort of be in the spirit of it. You have to be deeply embedded in the case, and we study each one of the justices. Not that it was hard to figure out where Justice Scalia was going to be on this, or some of the others, but if you study what they do or what they've said on various different cases, you may, when they start to speak, be able to answer a question. I'll say one more thing about oral argument. You have 30 minutes per side in the typical case. I've been asked 50, 60 questions or interrupted 50 or 60 times in 30 minutes. And they will interrupt you, and they will interrupt one another, and they will interrupt your answer, and that sort of thing. So just that set the stage a little bit. Justice Scalia said, and it is okay, you're asking us to decide that gay and lesbian citizens have a right to marry. In the 14th Amendment to the Constitution, which says equal protection and due process, it doesn't say marry. It doesn't say anything about sexual orientation. When did it suddenly become something that we have to decide? Was it the date of the Constitution? Was it the date of the 14th Amendment? Was it this date or that date? And there's no answer to that question, because the courts decide cases when they get cases. And they discern what those principles are. These are relatively elastic principles: equal protection, cruel and unusual punishment, due process, reasonable searches and seizures. Whatever people say about the Constitution and original intent and so forth, you've got to put actual facts into those concepts. So my answer to Justice Scalia, because it's the only answer that came into my head, and I've thought about it since then, people have talked about that particular moment, and I said to him, well, when did it become unconstitutional to put young people in schools, separate schools, because of their race? When did it become unconstitutional to prohibit people of a different race from marrying one another? Because I felt that would make the point, not that I would convince him, but you're speaking not just to him, but you're speaking to the rest of the justices, you're speaking to the world. I wanted to make the point that this was a constitutional concept or principle, that when the court decided Brown versus Board of Education, which was the race segregated schools, or Loving versus Virginia, which was prohibited restrictions in 16 states at the time in 1967 from people getting married to someone of a different race, that isn't the moment that it became unconstitutional. That's the moment that the Supreme Court recognized that it was unconstitutional. So it was a very interesting piece of the dynamic of what it's like in the Supreme Court and how things work in the Supreme Court. And that's the best that I could do. And if I was to do it over again, I couldn't do any better than that, at least in my opinion. Lots of people maybe couldn't.
Do oral arguments matter? I've heard Clarence Thomas say no one pays any attention, but you have said over and over again in the last half hour that you're talking not just to the court, but to America.
You're
You
talking.
really emphasize
Yes,
that.
in oral argument. First of all, we are advocates in the Supreme Court, and we work really hard to be prepared for an oral argument. So we have to believe it makes a difference. And I do believe it makes a difference. It may not change the outcome in very many cases. It has changed the outcome in some cases. Some of the justices have said that. Justice Kennedy said that in a connection with a case. I won't get into the details. It may make a case. Some people say, well, you can lose a case in oral argument, but you can't win a case in oral argument. And I've seen people make huge mistakes with respect to answers to questions. Answers to questions may illuminate what's going to be in the opinion, because it's not just the decision, it's what the Supreme Court says the law is in the opinion. And you may affect how that is all determined. And I was convinced, we had a procedural issue in this case of it standing. The people that had put Proposition 8 on the ballot had been the one to appeal, not the state of California. There was this subsidiary issue about standing, and when my opponent got up, the first thing that the court did was start asking him about the standing question and the procedural stuff, and it was 5, 7, 8 minutes before he got into constitutional rights. I knew they were going to do that to me. So when I got up, I had some things I wanted to say, 2 or 3 sentences about what this case was all about. I wasn't speaking to the justices at that point. I was speaking to the public, and I was speaking to the people that I represented, because I knew they wanted me to say something about who they were and what their rights were. So I said, I understand you're going to want, I can't remember the exact words, but I know we're going to want to get to this, but before I do anything else, I want to put this case in context. What the context is that the citizens of California have erected a wall around their gay and lesbian citizens and walled them off from one of the most important fundamental rights, the right to be treated equally and the right to marry. I got those words out. And I knew that people were going to be listening to the broadcast would hear those words, and that's what they wanted me to be saying in the Supreme Court. Then the Chief Justice interrupted me and said, well, let's get to this. He said, I'm going to have to do this, and I said, well, I thought you were about to do that.
So, David, you mentioned the Obergefell case, the case that's going to take head on the question of whether a state can stop same-sex couples from marrying. Would you just give us a sort of a guide? How should we watch this case? How would you two approach the case if you were arguing it? And if you were on the other side, how would you approach that?
Well, the case, just for background, is the Sixth Circuit Court of Appeals, which is the federal court of appeals that deals with Michigan and cluster 4 Midwestern states, Kentucky, Tennessee, Ohio, decided that there was not a federal constitutional right to marriage equality. It was the only federal court of appeals to make that decision. Ted and I had earlier in the year a case from Virginia where the Fourth Circuit had decided that there was a federal constitutional right. The other side had asked the Supreme Court to review that decision, and the Supreme Court had said no, and let that stand. But this was the first time that a court of appeals had actually decided against marriage equality. And there are 2 issues that are going up to the Supreme Court. The first is there a right to marriage equality? That is, can a state limit, based on sexual orientation or gender, who you marry? That's the first and most basic question. The second question is, if a state can do that, does the state have to recognize marriages that were performed in a different state? For example, in Ohio, the case that's coming up from Ohio is a recognition case. It's a case in which people were validly married outside in Ohio. They came into Ohio, and Ohio would not only not allow people to get married to people of the same sex, but they wouldn't recognize a lawful marriage someplace else. And that raises questions under full faith and credit, and the constitutional provisions that are designed to make every state respect what other states have done. So those are the two basic questions. Now, if, as we hope and expect, we win on the first issue, you never get to the second issue. Now, they will argue both issues because they won't know at the time. But in terms of analysis, if you win on the first issue, you never get to the second issue. On the first issue, the issues there are exactly the same arguments that we made in Perry, and we believe they're the same arguments that the court dealt with in the Windsor case. The Windsor case was the case about the so-called Defense of Marriage Act. There was congressional desire to name things the opposite of what they are doing. The court in Windsor held that the Defense of Marriage Act, to the extent that it refused federal recognition to marriages that were validly entered into in a state, was unconstitutional. Now, that's a different issue, but the reasoning of that decision, and the reasoning, indeed, of the Lawrence against Texas case, in which the Supreme Court in 2003 had held that a state could not criminalize homosexual conduct, that reasoning, I think, applies in the marriage context as well. And not only do I think that, but Justice Scalia thinks that, because although that didn't stop him from dissenting in Windsor, but in his dissent in the Lawrence case, he said, game over. He said, if this is the rule, then states cannot limit marriage to people of different sexes. He says, once you take away the underpinning of calling different sexual orientations immoral, you've taken away any constitutional justification for not allowing people to marry. And he was right then. He said the same thing in his dissent in Windsor. I think he was right then. And I think that at least 5 justices of the Supreme Court are going to take that next logical step in June. Now, you ask, what could you do on the other side? I don't have a clue. I really don't. I mean, what lawyers are trained to do is figure out what are the arguments that you would make if you were on the other side. That's the way you prepare a case. That's the way you know how to fine-tune your arguments. I could figure out what I would say if I were representing Microsoft as opposed to suing them. I could even figure out things to say if I were representing George Bush as opposed to Vice President Gore. I don't have a clue what I would say because they don't have an argument. There's not a principled argument. There is a religious argument, but religion can't play a role in defining constitutional rights. The First Amendment precludes that. And in terms of a constitutional argument, a policy argument, I don't see what it is. I mean, the other side has a bumper sticker that says marriage is between a man and a woman. As I've said before, that's not an argument. It's not even an answer. That's the question. And I don't think they have anything beyond that. And one of the great things about a lawsuit, and Ted and I did not go in asking for a trial. We wanted to get this resolved on summary judgment, preliminary injunction. The judge wisely said, no, I want to hear a trial. This is important enough. I want to hear evidence. And one of the great things about a trial is that it's hard to sustain a position for which you have no principled arguments through a trial. You can sometimes get away with that in a political debate. You can get away with that in a speech. But when you're subject to cross-examination and you're subject to day after day after day with the other side and the judge asking you questions, it's very hard to sustain a position that is not supported by principle. And I think that's what you saw in the trial. That's what you've seen on the appeals. And I think that's what you're going to see in June.
It's interesting, you just mentioned the separation of church and state. I was talking to Steve before, and he wondered and I couldn't answer the question, why the 14th Amendment rather than the First Amendment as the main vehicle for these cases? Or could it have been either?
Well, let me take a stab at that. The 14th Amendment has been the reason why we don't discriminate against classes of people. The First Amendment doesn't say that. And the Due Process Clause that's in the Fifth Amendment applies to the federal government. And then the 14th Amendment came along and applies to the states. What we've talked about here with respect to this issue is that fundamental rights may not be taken away from you without due process of law, and marriage is a fundamental right in the way we've argued it. And we have 14 or 15 cases in the Supreme Court in different contexts that say that marriage is a fundamental right. And our opponents said, well, those cases didn't involve persons of the same sex. But they did involve marriage. The Lawrence case, which involved conduct between persons of the same sex in Texas, did, and marriage was mentioned in that context. It was mentioned in the context of abortion. It was mentioned in the context of contraception and many other things. So the fundamental right that we were talking about, that comes from the Due Process Clause, and then secondly, what goes on here is the persons that are being selected out to be denied that right are because of their sexual orientation. So we've got a class of people, and the Supreme Court has recognized sexual orientation as describing a class of individuals. So you've got both of those coming together, and that's made, in our judgment, and all the courts that have done it since then have agreed with us, that that's the fundamental basis and the strongest arguments that you can make with respect to treating people right. The other one more sentence, Justice Kennedy was a very pivotal person here because he's been a swing vote he's been a pivotal vote in a lot of different cases involving constitutional issues. He is extremely sensitive to how we treat classes of people in this country. He's very concerned when there's laws or regulations or statutes or conduct that puts people in boxes. He does not like that. He said in one of the cases, he quoted an earlier case, we don't discriminate against classes of people in this country. So a big part of the emotional impact of this argument, you can talk about fundamental rights, but when you were talking about making people different, which is violation of what this principle this country was founded on, that resonates emotionally as well as legally.
I want to give students or anybody in the audience a chance to ask questions. So here's one last one for me as you make your way to the microphone. And fair warning, if you don't, we'll just keep talking all night. So you guys are at the top of the legal profession. Two questions for some of our students. First, what advice would you give to students here who would like to be lawyers? And secondly, what advice do you have for the students who'd like to be lawyers when they argue before the Supreme Court?
Oh, okay. Well, I think the legal profession is one of the best things that can happen to a person if you have the disposition to do that, because it is a learning experience your entire life, particularly with respect to when you're doing litigation, when you're representing people, you're representing legal issues, and you're having to learn something new. I've been doing it for almost 50 years. I'm learning something all the time. Every case is different. It's an enormous challenge, but to be able to, it's competition. It's devising ways to win cases. What's the best argument? How can we counter this argument? And so forth, to figure out a solution, to figure out how to put it in perspective, how to figure out what's the right question, and then to study. Maybe go back. I've had cases where I've gone back as far as the Magna Carta to look at legal principles. How did they work from the Magna Carta to the English Bill of Rights to the Virginia Bill of Rights to the Bill of Rights, and so on and so forth. It's fascinating. So, if you want to go into the practice of law, I mean, this thing is that you want to like history, you want to like talking about things, you want to discuss issues, you want to be able to write and speak. So law is communication. So having the substantive knowledge is one thing, to be able to communicate it is the other. And I'll let David talk about the Supreme Court.
But I do agree, and I think whether it's the Supreme Court or the practice of law, the thing that you have to be able to do is you have to be able to be objective, you have to be able to analyze something, and you have to be able to communicate your analysis. And so whether it's philosophy or history, it teaches you to think and reason, mathematics, or any of the courses that teach you how to communicate, any of the literature courses, any of the writing courses. Because what you have to be able to do is you have to be able to think and analyze and then present, communicate what it is that your analysis shows you. And I think that's, that's true for any court. The Supreme Court is like every other court except for two really critical differences. First, there are 9 judges. You hardly ever find that many judges in even a state Supreme Court. And that makes the argument much more difficult because you've got 9 people throwing, or 8 people, since Justice Thomas doesn't ask questions, but you've got 8 people throwing questions at you. And you have to be prepared to deal with that. The other thing is that they're all really well prepared, and they're all pretty smart. And so what happens is they will think of issues. You really, as Ted was saying, the preparation is so important because they will think of an issue no matter how hard you work. One of them or their clerks will come up with some case or some thought that you haven't prepared for. And you have to have enough preparation so that you can figure out that response right there when you're standing up. And that takes patience. I think probably the most important thing a lawyer needs is actually patience. It's patience to listen. It's patience to do the hard work to prepare. And it is patience to take that moment when you think you have the right answer, just to think about it for half a second before you start to give it. And that's I think that's true every time you appear before a judge or a jury, but it's particularly true in front of the Supreme Court because the stakes are high, but the quality that you're facing and the variety of what you're facing is so intense.
Okay. Professor Calabresi.
Thank you. Assuming the Supreme Court rules, as we hope and expect it will, in June, that government cannot discriminate on the basis of sexual orientation, there'll still remain the issue, which I talked to David about earlier, of private discrimination against people because of sexual orientation. And this has especially been an issue with respect to the Boy Scouts. A number of years ago, the Supreme Court decided a case, Boy Scouts against Dale, dealing with the issue of private discrimination on the basis of sexual orientation. There have been proposals to amend the Civil Rights Act of 1964 to ban discrimination on the basis of sexual orientation by private employers. I wondered if each of you can say something about that issue and how you see it developing.
Sure. Maybe I'll go first, and then Ted will chime in. I think you're exactly right. I mean, we are in the battle for equal rights with respect to sexual orientation. We're sort of where the country was in the late 1960s, beginning with the 1964 Civil Rights Act. We were eliminating the last vestiges of official discrimination. Probably the last significant one in the racial area fell in 1967 with Loving against Virginia that Ted was talking about. But we still faced enormous private discrimination. Private discrimination that we haven't eradicated, today. And what was critical there was that there be public remedies for that private discrimination. And a jurisprudence developed in terms of what could constitutionally be done to remedy that kind of discrimination. The government is not free to simply reorder society and tell people what to think and what to do in every regime. I mean, for example, the government cannot come in and tell you that you've got to, a minister or a priest can't advocate that his or her religion believes that marriage should be limited to people of different sexes. That's a matter of freedom of religion that the First Amendment guarantees, just like it precludes establishment of religion. It precludes using religion as a basis for this kind of laws, but also forbids government from telling people what they have to believe. There was a case in Massachusetts as to whether a St. Patrick's Day parade group had to allow a gay or lesbian contingent, and the Supreme Court decided no. And I think decided unanimously. I don't remember that, but it was overwhelmingly no. And so when you approach this, you have to be conscious of how do you craft that legislation. Now, a lot of states already have, and I think the first judicial battleground will be in applying those state laws to groups like the Boy Scouts. And the issue there is going to be, are the Boy Scouts, I mean, this trivializes it a little bit, but are they more like a church or are they more like a lunch counter? And they may have some attributes of both. But I think that those lines that are going to have to be drawn are going to be sort of the next judicial battleground, assuming that we win in June.
So we are running out of time, alas, so I'm going to take one more question here, and with apologies. Maybe we can talk briefly afterwards. Go ahead.
Hi, thank you. I was curious about the process that you went through. You were talking about refining your arguments and how you decided sort of what your best argument would be, whether there were any that you seriously considered and then decided not to pursue, how you decided what your most persuasive witnesses would be, and maybe even how you get them prepared to stand up to kind of the intensity of the judges when they might not have the same experiences that you have with that.
I'll start.
Sure.
And I'll do this briefly because of our time constraints. We honed those arguments, right? Because we started when we filed this case, the first thing we did was ask for a preliminary injunction, which would have stopped the state from enforcing Proposition 8. Right then and there, of course, we knew we weren't going to win that, but we thought that was create an opportunity for an appeal from a procedural standpoint. So we started honing those arguments. We started writing briefs. Then there were other motions during the course of the case up to the trial. Then we wrote opening arguments to give the judge an opportunity to know what we were going to do. Then there were the closing arguments. Then there was the courts of appeal, and then the Supreme Court. So we went over and over again. We had a very, very fabulous group of people from David's law firm and my firm, very bright young people as well as more experienced people, testing us, doing it back and forth, people taking the other sides and then arguing about it. So we went at this, we believe, nothing like preparation, so we spent a lot of time doing it. When we put on that, you ask about the witnesses, we felt the most important witnesses were our four plaintiffs, the four individuals who had suffered discrimination and were not being allowed to get married. We started with them, and we put them on the stand, and we just asked them questions. We rehearsed it in the sense that they knew a little bit about what we were going to be talking about, but we didn't prepare a script or anything like that, so it was spontaneous. They were in court telling about who they were, telling this judge what it was like to be discriminated against. And so that was important. Then we had expert witnesses from all over the world that talked about the history of marriage, the history of discrimination, the raising of children, and things that had happened to political science, where initiatives, how do initiatives work when there was a vote of the people on whether minorities get rights or not. So we had experts, which we also prepared. So the process is a long one, and I couldn't emphasize enough to have people arguing the other side inside your camp. Because people who don't listen to people who disagree with them will invariably get it wrong. That's why I love law school so much, because the professors would ask questions and then put you to the test, and then someone else would come in. You learn by hearing those things, and there are moot courts. You would make an argument And then you'd get critiqued by your colleagues, and you realize, well, it took too long to explain that. It was too complicated. It sounded too much like lawyers. It didn't, all of those things that were wrong with it. So you get better every time. And apropos of the question you asked before about preparing for this thing, I believe in every opportunity when I was in college and law school and everything else, every opportunity I had to give a speech that if I had time to do it, or write an article, newspaper, brief, whatever it was, write, speak, write, speak, write, speak. You'll be learning it your whole life. But as long as you keep after it, maybe you'll get incrementally a little bit better each time.
Well, David, did you want to?
No, I think Ted, as usual, said it very well. I mean, you want to do it all, and you want to do it all early. When you're trying a case, you never succeed, but you always try to hone your arguments right at the beginning so you know what to prove at trial. The worst thing is to figure out at the end of the trial, after all the evidence is in, that there was really an issue that you missed and you didn't put in evidence on it. So you try to do that, and I think one of the things that we did, and one of the things that we brought to this table, was not just ourselves, but our firms. And we had tremendous support from our firms, tremendous amount of resources that really allowed the kind of preparation that prepared the witnesses, got the experts, honed the legal arguments. It is preparation. There is no substitute for it. And the harder the case, the more important it is.
I don't know whether David kept count, but the number must be close to this. We did a calculation at our firm. From beginning to end, we had 32,000 lawyer hours in the case. And that's not counting David's firm.
Right.
And we had, when we put on the trial, we divided up responsibilities. It's another thing is teamwork and not trying to do everything yourself. We divided up responsibilities. I did certain parts of it, David did certain parts of it. A couple of our partners did this expert witness, somebody else did that expert witness, somebody else did this expert witness. David, who's, as I said before, the best in the country with cross-examination, did all the cross-examination. He cross-examined the other side's expert witnesses on video before the trial started. Most of them decided that they were otherwise occupied. When the trial came, all of a sudden the number of our opponent's expert witnesses started shrinking. I think they started out with 8 or 9, they wound up with 2. And the principal expert witness, and that's because they actually admitted they didn't want to go through cross-examination by David Boies in a public courtroom. The one man who was their principal witness was cross-examined very patiently by David over the course of a day and a half. And at the end of that cross-examination, he testified. He was their principal witness to support prohibitions on marriage between persons of the same sex. And at the end of that, thanks to David's patient, careful cross-examination, he said that America would be more true to its ideals the day that it recognized marriage between persons of the same sex.
So you've already got the applause, but let me say thank you. Thank you not just for being here, and we're all grateful for that, and we've all learned a lot, but thank you for everything. Thank you for what you've done for the United States. Thank you.